situation involving trusts and listings also.
Okay.
Okay, if a trust is your seller, okay, before you go any further, get Teresa a copy of the trust or certificate of trust, whatever, so we can make sure the person signing your listing agreement has the authority to sign the listing agreement. This is many, many years ago, but I use it as a big example. This is way back Rocky Craig time, where he was ecstatic. He had the largest sale in Birmingham Bloomfield office because trustee was selling the property. This is back in '78 and was an $875,000 sale. The problem was when I did the title, the brother who signed it was one of three brothers that were trustees. The other two were in Africa on a safari and wouldn't be back for 30 days. And this brother was trying to sell it before they could stop him from selling it. And anyhow, that was on a trust agreement. The party who has the authority to sign the listing agreement is the same one that would have the authority to sign the sale documents. So we need to see the trust to see what authority there is. And some of them have that the trustee, we'll say husband and wife initial, typical revocable living trust. The husband has passed away. The wife is now the sole trustee. Where we get a PA signed by the son as successor trustee. Okay, we need to know how. Is she declining now to act as trustee so that he can be the successor trustee? Is she mentally incompetent? So we need two doctors to pay two doctors saying, yes, she can't do her own actions, or is she passed? We're gonna, anytime we're dealing with successor trustees, we need to figure out how they got into it. I hate to tell you how many times the mom's lost it. I'm selling her house after we put her in the home. Okay. You don't have any authority to do that. I mean, not unless mom says you do. Okay. She has to resign. So get that to Teresa right away, anytime it's a trust, so that we can look at the title to see whether it's in that trust. And if it is, what authority is in that trust? And do we have a proper certificate of trust so we can go forward with a listing and a closing? Trusts are the preferred way, frankly, in many cases, to decide how the property goes. Because if you go through probate and you have unless you write a will that says, I acknowledge that John is my son. I intend to leave him nothing. Therefore, I leave him nothing. He has had no use for me in my life. I have no use for blah, blah, blah. You need that kind of language to exclude John if it goes into probate. If it goes into a trust, you don't have to put that. You can say, you acknowledge I have 3 kids. I leave everything to 2 kids only. You don't have to go into the theatrics that you need to do in a will. Now, as an aside, one of the topics lately that there are a lot of gay marriages. Some of those gay marriages occurred before Michigan recognized marriages. Once that Michigan recognized gay marriages, that was a good marriage. If John Smith and Harry Jones were married in whatever state allowed it then, and bought a property, John Smith and Harry Jones, a married couple, okay, prior to him being recognized in Michigan, if John Smith passed away, 1/2 of the property would go to his kids, okay? Or if Harry Jones passed away first, 1/2 would go to them. Once that marriage is recognized, there's a survivorship. So if John Smith dies first, John Smith's kids get nothing. Harry Jones has everything under the change. So many of the marriages that were prior to Michigan recognizing them, the 2 parties now need to convey to a trust so that they could have their heirs, because many of the couples have children from prior heterosexual relationships, and they want to make sure their kids get their half. They have to take it into a trust to do it. They can't do it. They leave it as husband and wife, because of like as a married couple, then the survivor gets it all. Okay, so I don't know how many of you work with gay couples, but I've done a lot of work over the years with gay couples on how they should take title and why. And this has been the big warning blow to all gay couples who were married prior to. Make sure that you understand what happens if one of you passes away.
What is that prior to date?
At 17, but I don't remember the exact date. That's where Dana Nessel made her name, being the attorney that's got the yeah.
Somebody, I have a question relative to that. Somebody asked me if they put their property in a trust, can they still do that principal homestead exemption?
Yep.
They can, okay.
Long as they are the benefit, long as the party occupying is the primary beneficiary. Now, you may have to go talk to the assessor to prove, but if Phil puts it into the Grandview Trust, okay, it's not going to be very obvious to the assessor that it's Phil, okay? If you put on the Phil and the Phil Trust, you're pretty much okay. But if you use some oblique name, then you got a problem with it being recognized. Then you have to make sure that the assessor, that you file and the assessor agrees with you.
A lot of times when I meet with people, they think it's in a trust, but apparently it's not. There's something called
Yep.
Baby Bird or other things. Should I have them sign the exclusive agreement as John Doe, trustee, and John Doe personally?
That would be the safe way. On a Ladybird deed, if I deed from myself to Stacy and Jason, but reserve the right to convey the property, okay, I have the right to sell it. Okay, Stacy, if I pass, the title's in Stacy and Jason's name. Okay, as opposed to being in my name, no probate. So in that situation, you know, the reason, frankly, you do it both ways is if they sign the listing and then pass away, okay, who is the owner at that point? You got the kids technically as the owner, but you have a binding agreement on the kids. Because they signed it during their lifetime when you could pull it back. So that was a part of the rights you reserved was to execute a listing agreement.
One thing though, and I've had you do this with me before, the title company can get the last deed recorded to prove how they're taking title, because a lot of times that's
Yep.
the situation.
Oh, yeah.
So if you have that issue, you can just email me, call me, whatever. We'll see what the last deed or record shows. That way you won't have to do the extra work. You'll know how they're taking title.
No.
And then what about this affidavit of certificate or certificate? How many every years do they have to update it? Like I had one recently that was from 2007, and who knew that was old?
You mean certificate of trust?
Yes, how often do they have to be updated?
Well, we'd like to have them be no more than 2 years old.
2 years, okay.
The reason for that is people change their minds and amend their trusts. Like every 5 years, I review mine, okay, just to because things change. My trust is from 1984. It's been reviewed and restated quite a few times, okay? As grandchildren have come into being, as children became of age, I mean, there's a lot of things that would cause it to be changed. And if you have a trust and you have not reviewed it, okay, and it's over 5 years old, go back and read through it to make sure it still reads as you intend. You'd be shocked. Holy mackerel, didn't think about that. Yeah, things have changed. They're married now. Okay. Okay, so the trust agreements are also one of the more common things right now that it's with the sellers, because as we're seeing, there's one of the reasons for the shortage of listings is frankly Uber and Lyft, because seniors are staying in their houses rather than going into a group home with COVID. And with Uber and Lyft, they can still be mobile. They can have their groceries and their drugs delivered, whatever. And we're seeing many more of the, what I call senior sales. There are people who have passed away, not because they've moved into a group home setting now. So we're dealing with successor trustee because of death. That's not so often successor trustee because of mind or where they're at or whatever. It's just a phenomenon that all of the homes, you have independent living, and that used to be 5 to 11 years that people stayed in independent living before they went to assisted. That first 5 years is gone now. Every people with independent living facilities are aware that demographic is not as big as it once was because people are not moving into independent living. They want to stay safe, quote unquote. So those houses don't go on the market.
It's just a really amazing, I can't even think the word, like cascade,
Yeah.
impact that who would have foreseen that, like, a massive.
One other quick comment, you've read a lot about how the foreclosures coming up are going to affect the number of listings going on the market. I personally am of the belief that there will be very little influence because what Fannie Mae and Freddie Mac have looked at, these house values have gone up dramatically. So they're no longer a bad loan to value situation. Fannie Mae and Freddie Mac got burned for a lot of money in the foreclosures before. If that loan to value is back up, so it's a good loan, they'll put the interest at the back of the loan. It may have been 30 years, now it's 32 years, whatever. Okay, rather than foreclose. So now the ironic thing is, the person that's in the house that now got Fannie Mae, Freddie Mac, to do this, can't buy another house. They have poor credit. They didn't make any payments all this time. So if they want to own a house, the only house they're ever going to own is the one they're in for at least 2 years, probably 5 years. So that house isn't coming on the market. Okay. It's one of those, as you said, cascade effects that, okay, not only is that house not coming on the market, they can't put it on the market because they can't buy anything else. They can only rent. You get some crazy things going on when you start pulling that thread and just looking at what the net effect is.
But they may not know that.
They're getting educated to that. Yeah.
I'm
I'm sure if they
thinking
don't
about
make a
sitting-
payment, though, that's when they get educated, is that?
Well,
or not?
there are lots of formal forbearance agreements out there. And those forbearance agreements are being reviewed for what's the home value on those properties. They're truly looking at them rather than just, I looked pass-throughs. They're actually looking at them now.
But when we take a listing, if their seller doesn't tell us they haven't been paying their mortgage, we don't know.
No, yeah, there's
We
no
don't know if there'll
reason.
be enough funds from the buyer to close.
Well, put it this way, we're not going back to short sales realistically because the home values have gone up so much. I mean, that has gotten rid of short sales in a big way as the value increases.
So at some point, maybe there's gotta be a question on the listing appointment about, is there any forbearance involved? And they can either tell you yes or tell you no. But
Well, if you want to, I don't
when
think
do we
it-
Find out.
I don't think it's really necessary because the values are going up, so you're not dealing with a short sale like the forbearance used to mean.
You're not dealing with a deadline.
Yeah,
is my-
yeah. Now, if there's a foreclosure involved, that's a different
Yeah.
story. Okay.
But if they're selling with the idea of buying something else, they need to get with a lender and figure out.
See if they can.
do
Yep.
that.
Yep. Yeah, lots of lenders are, put it this way, 2 years is pretty much the minimum if you haven't been making payments, and if you're under forbearance agreement, maybe. Okay. But you don't want to get them over to a hard money lender where they're paying 11% or something either. Or maybe they want to. I don't know. I'm just saying, I don't think so. Any questions anyone has? Who should I cover?
Well, were you gonna talk about the quiet title issue?
Oh, that's right, the FOIAs and
questions?
okay, tax sales. Okay, let me explain a tax sale situation. When the county forecloses on the taxes, they have to give all parties of interest notice that they are going to do that. Like if you're a mortgage holder you're entitled to notice that the parties haven't paid the taxes, and you have a chance to come in and pay the taxes to preserve your mortgage position. The question is, what's the quality of the notice that is given to the parties before they're eliminated? In Oakland and Macomb and Livingston, there is a huge effort to make sure every occupied door is knocked on. Okay, and if that house is occupied and no one comes to the door, you got to go back as a process server if you want to work for the county, those 3 counties. The statute requires that there be notice given by certified mail, by posting the property, whatever. We as title companies will not ensure that that is good notice unless there's been personal service, because the courts are not very amenable to saying that the people should have no one or could have no one, and so therefore they lose their property and all their rights. So, and let me give you the example of Wayne County, why we don't rely on Wayne County, okay? We require quiet titles in most cases. They posted the property, and they took a picture of the posting on January 22nd. There's one problem. There was green grass and no snow, okay? That kind of made their posting suspect as far as when they did it. And that has been true of many of their postings. So in Wayne County, unless there's a signature, we won't even consider that to be good service. Now, Oakland, Macomb, and Livingston, we might ensure if it's good service with actual signatures without 10 years passing. So you have to go what's called a FOIA package, Freedom of Information Act package, from the Treasurer's Office that will gives us what service they have done. That if your client wants to save somebody and speed, they can request it from the Treasurer's Office, pay the $30 to $40, pick it up and deliver it to you to deliver it to us. If we need to order it, it's $150 and it will take at least 2 weeks longer. We are not voters, we're only a title company, okay? So that's, so it'll be better off if your seller goes to get that, saves the money and it gets it done quicker. That will come in, we'll review it to determine whether the service is good. If the service is okay, boom, we're okay to go forward. If it is not, we will tell you in the commitment what parties need to be joined in a quiet title proceeding. A quiet title proceeding is where you, bank, you, John, both have interest in the property, step forward and prove it, redeem, do whatever, or you're out. And if they don't, they're out. And we record the quiet title judgment and that party is gone from the record. Now, Wayne County, you're probably looking at 90–95% of the cases require quiet titles. And if you're dealing in Livingston, Oakland, Macomb, you're probably dealing with more like a 15 to 20% that require quiet titles because of the way they do it. There's a company out of Kalamazoo called Title Check that many of the other Treasurer's Office use. They are worthless. They follow statutory only. In other words, they mail it, they tell you they mailed it. They have no signatures, no personal service proof. So if they did it, yeah, it's going to require a quiet title because they didn't give notice to anybody. In a way satisfactory to us.
So if you get a listing, you think it's okay, and then when we get the title commitment back, it's got somebody else's name on it, that's when we should go to our sellers and say,
Yeah, our commitment will state whether or not it's that they acquired it by a tax sale and
because we
But-
currently have one of those.
okay. Yep.
So you, I will say you.
You have a
Phil
quiet-
and I have talked a lot
Okay,
about
yes,
this.
yes.
I've been bugging Phil quite a bit, but we were in the middle of a quiet title
Yeah.
actually now.
You have
Now-
to do the same thing with the quiet title when you have a defunct bank that didn't discharge a mortgage?
Potentially, yes. The problem is identifying who to serve and for that defunct bank. And if, unfortunately, Wayne County, where they had one judge that was assigned to all quiet titles, and he was great to work with. Okay, he understood how badly Wayne County handled the notices. And you could go in and you would ask him beforehand, is this going to be satisfactory service to you? And if he said no, you bring in an order, a request to do it that way. We're gonna table that. Okay, I thought we already discussed it. You can't get another hearing for at least a month if you're that stupid, okay? But he was very, very good. He was a pleasure to work with. Right now, they've got it sprayed all over the place because nobody wants to have just an agenda of that. And so you have no judge with knowledge now. So it's every case by case, unfortunately. Like we're playing
We're in
peekaboo here.
Oakland. We're in Oakland, we had Judge Matthews think.
Yeah. But yeah, the bottom line is that if it's a tax title, I can't tell you it's good or bad until I have the FOIA package. And once the FOIA package is reviewed, then we submit it to the underwriter, but I won't submit something to the underwriter that I can't recommend to them. And they've never turned me down on a recommendation yet. But I also don't send them something they can't approve either.
And then you were gonna talk about marijuana